swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statements, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in, the witnesses have testified, the exhibits have been admitted, and if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they caused someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation? Who caused the incident? And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, and then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And later this morning, may stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor. That misstates the testimony.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on this scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-bill cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and and makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021 she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021, is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulligan. She went to plastic surgery 4 years later after being in a car accident.
Objection, that misstates.
By the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today, that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower, I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume the plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tierra Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Objection, you're not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming, but her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. You know, we all have relatives, and we hope our parents believe us, and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay? We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything, and they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say, guess what, Mom, guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out. Because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay? Well, that sure doesn't square with the testimony of Tierra Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek? But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Imani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday. Question, you didn't call your grandmother though, did you? Answer, no. Okay? So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired, and as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulliken. Okay, that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24th, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar. That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay? That's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show then we'll show, this was played for the jury before.
Okay.
It's plaintiff's testimony as to how she was supposedly cut by Cardi.
When you say like this, she put her finger?
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and two other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claimed scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with a straightened finger. And to add to that, Cardi is not right-handed. I want to say that again, it's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about how well-respected he is, that it was a right-handed person who scraped 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claimed scar, but that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Objection, that misstates the testimony, Dr.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulliken's testimony. For example, he calls a 3-minute-long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulliken testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or Dr. Mulliken also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulliken, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulliken also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulliken. Dr. Mulliken knows that he is going to get paid, if at all, his $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive, and because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated, and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want.
Okay. All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please don't discuss the